Hey everybody, this is Carrie Smith with Dentist Secure, and I'm with Carrie Douglas at Strasburger. Say hi, Carrie.
Hello, everybody.
This morning we're going to talk about employment contracts and some of the things that we look at when you're either graduating from school or moving from an associate job or looking for employment. And the reason why Dentist Secure and Carrie Smith are concerned about this is because when you look at these contracts, it does pose some sort of risk in terms of financially. It may get you in a position that would affect your options in the future. So it's real important to know some of the details that go into these contracts, and Carrie's our expert that knows how to do this. So we're going to jump into a presentation here and just kind of talk through the top 10 things that you need to look at. And if you have more questions as we go or need to reach out to us, we're going to give you contact information at the end so you guys can get a hold of us. So, all right, here we go. Let's talk about the top 10.
Great. And to echo what Carrie was saying, your first contract, and really any contract you enter into, liken it to a prenuptial agreement. For better or for worse, you have now married your group, your employer, or your independent, or the folks that are hiring you to be an independent contractor. So you really need to keep that in mind when you're signing these contracts, because not only do you need to know what you have to do going into it, but you want to know how to get out of it, how to extricate yourself. And that's really what I worry about as a healthcare attorney, is what are the biggest mistakes that I can envision y'all having when you're entering into these agreements.
Okay, Carrie, so talk to us about the top 10 things that are going to go into a contract and what new dentists need to look at and be concerned with, okay?
Certainly. So mistake number 1 is consulting counsel too late. And this is a very critical thing to keep in mind, because you want to have somebody that not only is an attorney that has employment experience, but also has healthcare employment experience. There are different parameters and restrictions when you're dealing with healthcare versus other areas and disciplines. So it's important to have somebody with a specific knowledge base. You may have a friend that's in the real estate area, or a great friend, or you may have somebody that's in corporate. They're all great people to know, not for this particular area. Mistake number 2 is failing to conduct adequate research on your prospective employer. As I said, this is like a prenup, so you are marrying your group. If your employer has a bad rep, that reputation is going to follow you to the next job and the following job. So you want to make sure you've done your due diligence on who you're getting into bed with, so to speak.
Yeah, that's really important as far as malpractice goes, because when you are an associate dentist and you work for a company, your name is on that chart. And so if a subsequent injury occurs, or even if an injury does occur while you're the treating doctor, that company's risk that they bring to the table will stick with you even after you leave. Your name could still be dragged into a lawsuit because your name is on the chart. So choosing the right employer up front and making sure that they have the right disciplines in place will help you with your professional reputation as well. So.
Absolutely. And just so you know, you have to constantly report for privileging purposes, for credentialing, any lawsuits that you've been named in, involved in, even if they get dismissed, even if they were found to be frivolous. These things tag you your entire career. So this is a critical area to keep in mind. The next one is overlooking the vague term of the contract. There's a lot of legalese and mumbo jumbo, for lack of a nicer term, that goes into these contracts. If you don't understand it, my suggestion is do not sign it. This is where you need to really ask people, what does this mean? And if you think you understand a definition by Webster, but they define it differently in the contract, that's not what the definition is. The definition is, it's not the unique, it's not the normal day-to-day definition. It's the unique one that the contract sets forth, such as a year. A year you might think is 12 months. They could have it 13 months. They could have it a calendar year, but then add on extra time from the effective date of the agreement. So those are other things to think about. Failing to understand the legal significance of defined terms, that goes along with the vague term of the contract. Again, if you don't understand how a term has been defined, ask the questions. You need to talk with the group, talk to people that have joined, that are your immediate predecessors at the group, and find out what's going on with this particular dental practice so you know what they mean by defined terms. One that I commonly see is evergreen. Evergreen means it constantly is going, what an evergreen means is that it's constantly going to be renewed. You would not know that typically, but that's something that in your cases, it affects how you can terminate at times. The next one would be not paying attention to fringe benefits. Fringe benefits really make or break a contract in terms of it's not just your salary, but it's also what else are they offering to you, whether it's CMEs, additional educational opportunities, types of call, and other type, insurance benefits, pension or IRA or 401k. So it's the softer things, but they're also very important, and you want to know what you're getting. And a lot of times what you'll see is just we give benefits akin to what other employees get. This is your opportunity to define what that is and make sure you're comfortable with it, because you don't have any other opportunity at the back end. It's very difficult to then negotiate.
Yeah, I think one thing on that one is not paying attention to fringe benefits is when you look at malpractice insurance, like does the group or does your employer pay for that malpractice insurance? Are you required to be on their plan? Can you do your own plan? These are the questions that we get from new grads, and so understanding like who's going to pay that insurance. Now, there's some downstream consequences of if you're on their group plan or not. From a malpractice perspective, even also in healthcare, like those sorts of things you need to be thinking about. If you do terminate, what do you have to do next, and who pays for what, and that kind of thing.
And also disability is a huge one. Whether or not you should go and get your own disability, I always instruct my clients to get separate disability from whatever the group is providing, and that's big because some disabilities are very weak, and that if you could practice as a dentist, but let's say you have a specialty within dentistry, you won't get any disability. Whereas there's some different policies where you can get disability coverage when you have to go from being an endodontist or a periodontist down to just a general dentist. And so those are things that you would want to talk with Carrie about and get a better assessment as to what your options are. And another thing is not specifying the conditions of employment. This is one of those that I see very often, and they do it because they don't want to constantly change. The employers do it because they don't want to change the employment agreement to be specific to each candidate or each potential employee. But the idea is you want to know what your hours are going to be, what your call, if any, is going to be, what your requirements are for emergency situations, what your training requirements are, how much vacation time you get, what your hours are, what your day-to-day is going to be like, what facilities you're going to be at. That's a huge thing later on when we talk about the non-compete. You would like to have it ironed out where you're going to actually be practicing. That's a huge thing about the offices. And so those are things that you typically you try to work through on the front end, but they're not deal breakers, but they are important to at least get a base knowledge as to what your particularized conditions are going to be. The next one is not having adequate information on bonus terms. Bonuses are very heated. Groups tend to play with it different ways. Some employers are very transparent. Others are very opaque. So what you're going to see is a mishmash of people saying, okay, we can give you we'll give you your bonus based off gross revenue, which for an employee or an independent contractor is fair because you're not sharing in the risk of the group and you shouldn't be having to be affected as much by the overhead. Other ones do it off of net, which can be very much manipulated. And so understanding where the bonuses come in. And the other thing is a lot of times bonuses are oral and they're not written. And I always say an oral contract is worth its weight in paper, meaning it's not worth anything. I'll give you an example. My father he's a gastroenterologist in Houston. He was told when he started his job that he was going to be given a Cadillac when he finished his second year. I'm still waiting to see the caddy. So when it was an oral promise, he didn't learn his lesson at that point. And so when you're given promises like that, they can renege, and that's what his group did.
Did they say it was a brand new Cadillac or a 1975 Eldorado?
Well, this was in 79, and so they were telling him in 1980 he would get a caddy.
Oh, gosh, yeah, it was an Eldorado then.
Yeah, it probably was. But yeah, he's still waiting for his Cadillac.
Yeah, so bonus terms are pretty critical to know on that because are you being paid on collections? Are you being paid on production? What are those terms? And almost whenever I work with dentists that are leaving an associate job and thinking about doing their own practice, one of the main complaints I hear of is that my employer wasn't upfront about how I was going to get paid. And what that tells me is that, no, the doctor perhaps wasn't clear enough up front in the negotiations on exactly how I'm going to get paid. You just took the job, and then now there were misunderstandings that occur. So it's on both
It's
parties to make
9 o'clock.
sure that we have this agreement in place.
Then the big one, if you leave with hearing nothing but this, is be aware of unduly restrictive covenants not to compete. There's a folktale out there that courts will not uphold it in the state of Texas if you are a medical provider. That is not true. I have played both sides of this argument. Courts very much will uphold these. What you want to do is make it as painless as possible. So Texas is unique in that you can buy yourself out of a non-compete. That's typically paying the group back 1 to 2 years of your salary. That's number one. Number two, you have to be prepared that it could be a 5, it could be up to a 25. Sometimes they put in 100-mile radiuses. If you see a radius of 100 miles to 25, that's typically going to be outside the scope of what a court would likely enforce. But a 5-mile radius to 10-mile radius is very much enforceable. Also, anywhere between a 1 to 3 year window of time is likely to be enforced. 3 years sounds like a lot of time, but the courts will do it. Sometimes the contracts have up to 5 years. Typically, for a healthcare provider, that will not be the case. If you're joining a group, then you're excited because it's expanding. That cuts both ways. Because typically what the groups will do is say, anywhere where we have an office, you cannot practice within a 5-mile, 10-mile, etc. radius. That said, if you've never practiced in any of the other offices, there's a good argument, a colorable argument to be made to explain to the group and to the court, this should not be enforceable, but you really need to understand what your non-compete provisions require, what they set forth before you sign the contract. Like I said, if there's anything that you leave with today, it's understand and know your non-compete and do your best to negotiate that provision down.
Yep.
And the next one is along these lines, failing to recognize one-sided termination provisions. This has become more and more common in the contracts I've been reviewing in the past 5 years. And what I've been seeing is that if you sign a contract, typically in your first year, you cannot leave it. The group can let go of you, but you cannot let go of the group. And they're doing that because it's an investment with you. They've spent a lot of money either recruiting you or training you. And so they're very leery of letting you go in under a year. It's not fair, but it's out there. And I've argued that you become indentured servants. That's been falling on deaf ears. So just be prepared that could be in there and recognize that it's there. And I do my best to get rid of it, but it doesn't always. That's something you need to be familiar with. Additionally, there's usually terminations without cause. So that would be like giving a 90-day notice. The notice time is very important. What I typically see is that there's a different notice window for the employers and for the employees. So if you're required to give 90 days notice, the group may only be required to give you 30 days notice. What that means is that within 30 days, you have no job. Whereas with the 90-day window, you have 3 months to look for and secure your new job. So I typically try to make them uniform and to be a 90-day window. I think that's important, and you want to make sure you have as much time to get into your new position as possible, but you don't want to be there so long that you can't have a decent relationship with these folks.
So when somebody terminates, just as a question I get, when somebody terminates employment on the contracts, I've been seeing that when they terminate employment, the employee terminates employment or gives notice, then the employer fails or is obligated or has the ability to not pay the doctor what's been owed.
Well, what they usually do is if there's a termination without cause provision, they put in that you will get your salary accrued, but you will not get any bonuses accrued.
Or like, what about outstanding collections?
The collections, they'll usually do it through the date of termination. So the day you terminate is not the day you resign. Okay. The day you resign, and then the termination date's 90 days. So they'll do it. You should be getting your collections through that 90-day period. But bear in mind that there's a lag with collections, so they may cut you off that day. I would negotiate that as well and say, no, you should get everything for a 90-day window after your termination. But that's critical because the employers want to keep as much money as they have. They want you to have as little money as.
Yeah.
And that's how. Unfortunately, that's how this works a lot of times. but you should get what you've worked. That's one thing. You may not be entitled to bonus because you didn't last the duration of the bonus period. And I can live, I don't like it, but I can always suggest to my clients live with that issue. But if you have worked it and there's and we know what the lag period is with managed care companies and insurers, it's very simple to get that issue addressed and say, okay, for 90 days following my last day of employment, I will then be treating I will then be entitled to what my collections would have been.
Got it.
The other thing that you can do is a lot of the contracts you'll notice will say you will get paid up until your last day, or the employer may elect as soon as you've given termination to just say don't come back. Mm-hmm. And then at that point, that kind of makes it easy on everyone because your last day is whenever they've elected, but there's no lag then with collections. You'll just get what you get.
Okay. So last one, mistake number 10.
Not protecting additional income.
What's additional income?
So if you've ever been asked to speak at a presentation like this, if you've been asked to be an expert, if you've written any articles, if you've consulted with any companies, those are all sources of income. The way the contracts are written are twofold. Number one, they're going to say that you owe a duty to only be working for the practice. And then they also will put in there that any sources of income that come in from professional obligations, such as the ones I just listed, are considered income of the practice or the group. When that happens, then you have to arguably give back the money you've earned from outside and extracurricular activities that you've done on your leisure at different times. And that's what you really need to protect, and that's come up a number of times. And employers typically, you can keep it to what we regard as a de minimis amount, and de minimis is between $2,500 and $5,000, they're willing to let that go. But you have to make sure to be upfront. And why I say this is, you sign the contract, it has that language I was mentioning where everything's considered income of the practice and is a professional fee and should be going back to them. And then they find out you've gone and you've given a talk or you've been an expert in a Texas dental board dispute, something of that nature. And then they find out you didn't give it back to the group. That's a material breach of your contract, and that can be something that cannot be cured. So then you could get terminated immediately with cause. And that's something that it just sets a bad precedent for you. That will tag your career as well, and it's not worth it. For especially, like I said, the amount's typically de minimis, but it's something that I think should be yours, and it's easily addressed up front.
Okay. So those are 10 mistakes. Obviously, when you're looking at working with an employer, there's a lot of specific contract things that you're going to need to look at. These are just general terms, some general things we want you to think about. So if you need this kind of help, which you do, you should have representation. The employers have their representation. They're looking after their best interest, and a lot of times the contract is something that protects their best interest and not necessarily focused on what's best for you. You need representation. These things can help by answering these things, these 10 mistakes, or hopefully avoiding them. You're going to save yourself a lot of heartache down the road when you decide that this relationship needs to dissolve. That's really where the quality of your advice comes through. Okay, so those are just 10 things. If you need more help with this, you reach out to me, or you can reach out to Carrie. We got 2 Carries on this thing, so it shouldn't be hard to remember our names. And so please reach out to us, and let's stay in touch and start a conversation.